US-based microblogging platform Twitter today opposed before the Karnataka High Court the orders issued by the centre asking it to pull down content including several accounts that made posts relating to the farmers' protests and alleged mismanagement of COVID-19. Twitter asked how it could be directed to block user accounts and muffle their freedom of speech when news relating to these events were freely circulated by television and print media. Alleging disproportionate use of power, Twitter had earlier moved the Karnataka High Court seeking relief from purportedly overboard and arbitrary content blocking orders from the centre. For context, the Ministry of Electronics and Information Technology had written to Twitter granting it one last opportunity to comply with a series of blocking orders issued under Section 69A of the Information Technology Act of 2000, while also setting out serious consequences for non-compliance, including initiation of criminal proceedings against Twitter's Chief Compliance Officer. Considering the seriousness of these threats, Twitter had decided to challenge the blocking orders issued by the centre before the Karnataka High Court. Arguing before Justice Krishna S. Dikshit, senior advocate Arvind Datta submitted on behalf of Twitter, and I quote here, "If on my platform 1,200 accounts are blocked even when material is appearing in print and TV, then it is causing prejudice." Twitter claims that if any particular account is against the interest of India, it is the first to act against it. However, when the government wishes to prevent certain accounts, it must follow statutory procedure. Today during the hearing, Datta submitted that as per the jurisprudence laid down by the Supreme Court in the Shreya Singhal vs Union of India case, if the centre finds some tweets objectionable, it has to send a notice to the account holder asking why the tweet should not be pulled down. He argued that blocking user accounts would be a violation of freedom of speech. At this juncture, Justice Dikshit inquired if the right of free speech and expression also applies to artificial persons like Twitter. Datta responded by saying that Section 69 of the Information Technology Act has to be followed. Section 69 gives the central and the state governments the power to issue directions for interception, monitoring or decryption of any information through any computer resource. He further submitted that this particular section does not allow for wholesale blocking of accounts. Significantly, the centre has filed a reply in this matter saying that it is not for Twitter, which is an intermediary platform, to decide what free speech is permitted and is in contravention with national security and public order. Apprising the Karnataka High Court, Datta today pointed out that the blocking orders issued by the central government are not compliant with Rule 6 of the IT blocking rules of 2009, which prescribes identifying the person giving the message and the intermediary. The procedure to be followed is that on receiving any information, the same must be communicated to Twitter before a decision to block and must allow Twitter to submit clarification as per Rule 8. As per the rule, an equal opportunity should be given to the account holder. On the contrary, the central government has straightforwardly issued directions to block 1,158 accounts, Datta said today. He also argued that several accounts that were sought to be blocked have made innocuous tweets and do not warrant interference in exercise of centre's powers under Section 69A of the IT Act. As the High Court focused on number of such accounts, reportedly 2.66%, Datta argued that statistics could paint the wrong picture in a case for individual rights of the 1,200 blocked accounts. He noted that blocking the entire account, more so in the absence of any time limit mentioned in the blocking orders, requires statutory safeguards. He also referred to a matter against Twitter in the Delhi High Court, where the ministry in one of the affidavits filed stated that blocking user accounts should only be done as a last resort. The matter is now listed for arguments on October 17th. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.